Donald Trump, who will, by the way, be in Michigan's capital in a short while, and Wisconsin later on. Wisconsin, where Republicans scored a big win Monday when the U.S. Supreme Court ruled that all ballots, no matter the date on the postmark on the envelope, had to be in by Election Day. It was a 5-3 ruling. This on the day when a sixth Republican-appointed justice was approved by the Senate and sworn in by the president. Selena Sykes has more.
The scales of justice in the Supreme Court are now tipped in the Republicans' favor. On Monday evening, Judge Amy Coney Barrett was sworn in at the White House alongside President Donald Trump, pledging to preserve the U.S. Constitution.
The oath that I have solemnly taken tonight means at its core that I will do my job without any fear or favor, and that I will do so independently of both the political branches and of my own preferences.
The yeas are 52, the nays are 48.
Earlier on Monday, the U.S. Senate confirmed Barrett to the Supreme Court after Republicans voted 52-48, overcoming a united opposition from Democrats. A devout Catholic favored by social conservatives, she is Trump's third appointee to the Supreme Court. The 48-year-old's lifetime appointment cements a 6-3 conservative majority in the top U.S. judicial body and a boost for the president ahead of next week's election.
This is a momentous day for America, for the United States Constitution, and for the fair and impartial rule of law.
Barrett fills the vacancy left by Liberal Justice Ruth Bader Ginsburg, who died last month. It's the first time a Supreme Court justice has been confirmed so close to voters going to the polls. For weeks, Democrats argued that the election winner should pick the nominee, saying that Barrett's vote would give Trump an advantage if the Supreme Court is involved in a disputed election.
And we're in the company of Douglas Herbert, and from Branford, Connecticut, Bruce Ackerman, professor of law and political science at Yale University. Thank you for speaking with us here on France 24.
It's a pleasure, Francois.
So we're looking at a 6-3 court, as it were, with 7 days to go till Election Day. Your reaction?
Well, one source of concern is that 3 of the justices were in Florida in 2020, and engaged in invoking the Supreme Court's lawless intervention into the process of counting the votes. I know because I was Al Gore's representative before the Florida legislature.
Lawless intervention? Can you explain that to our viewers?
Yes. Well, the crucial point, and this is why I would not worry about these decisions right now. The crucial point in the United States is that each state is responsible for conducting its own election. To have an analogy in Europe, the analogy is if the European Court of Justice intervened in a French election, this would be not legitimate. In the United States, each state is in charge, and it is not. There is no constitutional or statutory justification for the Supreme Court's intervention in the process. What we had was a lawless intervention in 2000. And later on, I assembled a symposium volume, The Question of Legitimacy, Bush against Gore, in which leading members of the judiciary and the academy, from the left and the right and everywhere, were united in condemning this as a lawless intervention. And now we have 3 members of the court, Justice Roberts, who was significantly involved, and Justice Kavanaugh, and now Justice Barrett, all three. Now, if they once again intervene, this will be a devastating delegitimation of the Supreme Court of the United States.
Yeah,
and
but
I should say
you mentioned
that
Justice Kavanaugh in that ruling on
Yes.
on Monday regarding whether or not they would count ballots received after Election Day in Wisconsin. He wrote, quote, "Those states want to avoid the chaos and suspicions of impropriety that can ensue if thousands of absentee ballots flow in after Election Day and potentially flip the result of an election." Your reaction?
I think that actually the majority and Kavanaugh were correct in this decision. That is to say, what this decision says, Wisconsin and Pennsylvania each have their own rules. And one of the fundamental rules that all states in one way or another have is that once an election begins, you don't change the rules of the game. If that rule, that fundamental principle, which in different ways is expressed in the law of every state, were violated, this would open the way up to last-minute political manipulations by the legislature. So the court was correct, in my view, in saying, look, the process of election is going on. As you pointed out earlier, in fact, there is going to be an overwhelming turnout in this election. And this is too late to change the rules of the game if that's what the law of Wisconsin or some other state says. I think that was actually the correct decision. I'm trying to give you my view of the law, if you'll forgive the expression, rather than my own views of politics here.
Understood. Let me jump in here, Doug Herbert in the studio. How do you respond, however, to the more progressive judges on the Supreme Court, and I'm talking once again about the Wisconsin decision, who basically said that given that the U.S. is in the grips of a fierce pandemic, the circumstances essentially warrant judicial activism. And why do they say it warrants the judges to take a more aggressive stance in this case? Because they say that otherwise they are essentially a lot of voters who might be endangered by going to the polls in a pandemic are essentially disenfranchised. Even if Republicans don't want to hear talk of the word disenfranchised, it amounts to that. And I'll go further and maybe you even use the term, it amounts to voter suppression by other means.
Yes, I generally oppose the easy and facile talk of states of emergency. I think that this is precisely the kind of talk that we're going to see when Trump, after the election, when we're going to really get the crisis in Congress, when Congress has to decide who is actually the winner, and Trump is saying, I'm going to use my emergency powers to challenge the outcome if Biden wins. This talk of a state of emergency has to be brought under control. And in particular, I do not believe that a court should declare an emergency. I actually played a supportive role in the modification of the French Constitution in revising de Gaulle's blanket assertion of power to declare emergencies. I think this is a very bad feature of a constitution, and we have to not only think about Trump. The American constitutional system is in a condition of crisis. It will take us a decade or more to reconstruct the foundations of the rule of law and checks and balances in our system, given the incredibly destructive assaults on our Enlightenment tradition, which begins with the American and French revolutions, and so this kind of judicially imposed state of emergency is just the thing that I want to condemn. In fact,
I was going to say,
yes.
Bruce Ackerman,
and doesn't have a basis in law. It doesn't have a basis in law. That's the key thing. Forget about my condemning. There is no basis in law for a Supreme Court to intervene on an emergency basis. This is just what the court did in Bush against Gore, and with shattering consequences on its legitimacy. But it will be just a hiccup compared to the another intervention by 3 justices who were involved in the first
in that decision in 2000, which you say was a very partisan decision, in your view. Bruce Ackerman.
It was 5-4, Republicans against Democrats.
Republicans
Absolutely.
against Democrats.
Yes.
And so, final question here. How will the Supreme Court behave itself in what you predict could be very stormy days following the election on November the 3rd? And more broadly, how will, if Joe Biden wins, how will he deal with this 6-3 Supreme Court?
Well, the crucial looming crisis is on January 5th, when the Constitution has 450 words, out of a document of 4,000 words, which describes how the Congress meets in joint session to select who won. And the presiding officer, I wrote a book about this called The Failure of the Founding Fathers. The presiding officer at this joint session is none other than Vice President Pence, who has very substantial discretionary authority to manipulate the procedures in ways that will lead to a partisan selection of Trump for a second term, even though Biden's vote counts are Biden won by, let's say, 350 or 400 electoral college votes and 20 million nationwide votes. Nonetheless, this elaborate procedure written by the founders and then modified by Thomas Jefferson is completely obsolete. The founding fathers didn't understand that we were going to have a two-party system. They didn't understand that everyone was going to vote. At that time, only propertied white males could vote. And they didn't understand that the Senate would be popularly elected. They had George Washington, who is, as my recent book suggests, is very much like Nelson Mandela. He's one of the very few revolutionary heroes who voluntarily refuses to run for another term. He refuses to become president for life. This was a period of the initial efforts to construct a democracy. And we should compare those to what was happening in France at that time. Also, initial efforts, which failed in France, but actually succeeded somewhat.
A system that you're saying is lay a foundation. Your system that you're saying is obsolete today. Bruce Ackerman of Yale University. So many thanks for joining us. Always a pleasure.
Well, it's a tragedy. Let's hope it doesn't really destroy us.
Okay. Well, we'll continue to cover it here, and we'll have full election coverage. Many thanks, Bruce Ackerman. Thank you, Douglas Herbert.